SJC-12681, Boston Globe Media Partners, LLC, v. Chief Justice of the Trial Court, and another.
Mr. Albano, good morning.
Good morning. May it please the court, my name is John Albano. I'm here on behalf of the petitioner. The petition in this case is based, I would submit, on three principles. The first principle is that absent a legislative directive to the contrary, records that are filed with the court are presumptively public under the common law, and the applications for criminal complaints at issue in this case are indeed filed with the court. The second principle is that that common law right of public access is strongest when the records at issue form the basis for judicial action, as is the case here.
Do you consider an inaction to be the same as an action?
I do not. I would submit that a finding of probable cause is a judicial ruling that is subject.
What if there is a finding of no probable cause? Is that not a judicial action also?
I suppose it could be considered a judicial action, Your Honor, but in this case, there is no claim made that in situations where the clerk does not make a finding of probable cause and does not issue a complaint, that the public's common law right of access
Are any
applies.
papers filed in those instances?
They are indeed. And they are in every case in which the clerk magistrate either issues a complaint or does not issue a complaint.
But you're not suggesting then that there'd be a right of access to the papers where there was a finding of no probable cause?
No, and the analogy, I should be clear about this, the analogy and the model that the petition follows is the rulings of the court with respect to access to search warrant materials and access to inquest reports. So for example, the cases beginning with New England newspapers are very clear that the public has no right to attend a proceeding in which a search warrant is being considered by a court. But the court also has been quite clear that once the search warrant issues, and under the statute, once the materials are filed with the court, the public's common law right of access does apply.
Can I ask you, Mr. Albano, whether you think that the opinion in Eagle Tribune was erroneous? I know you don't want to get there. I know you want to do, but I really do we have to do something with Eagle Tribune in order to get to where you want to go?
No.
No, despite the fact that the court describes the show cause hearing in ways very differently than what you're doing. In fact, says the thing that it's most akin to is a grand jury proceeding, not what you're saying.
Your Honor, the Eagle Tribune case, I would submit, did not address either access to records nor did it address what happens when a clerk makes a judicial ruling. So that's why I say I find this situation so analogous to the search warrant cases and the inquest cases.
So you say you can have access to something after the fact that you couldn't do before the fact?
Just as in the search warrant materials and just as in the inquest. So for example,
Not with the grand jury.
That's correct, Your Honor.
Right. So if we think that this is more like a grand jury proceeding, then the access is prohibited.
Well, here's what I would say to that, if I may. To say that there are similarities between what a grand jury does and what happens in a show cause hearing does not end the inquiry, because there are also significant dissimilarities between the two. The amicus brief, for example, of the Clerk Magistrates Association argues that all that's going on here is a little slice of the prosecutorial discretion that is afforded to prosecutors, the DAs and the Attorney General, has been legislatively pushed to clerk magistrates. I would say it's not that simple, because when a district attorney or the attorney general makes a decision to charge or not to charge, there is electoral accountability for it. When a grand jury makes a decision, the grand jury was formed initially as citizens to stand as protection against the crown, the government, and indeed the courts.
Well, but we've got the legislature. Is there anything prohibiting the legislature from addressing this and setting forth some procedures and rules or not rules, but setting forth a statute saying how they would like this to be handled?
There is not, Your Honor, but for these purposes, I think the critical issue is that these statutes, Section 35 and Section 35A, in no way abrogate the common law presumption that documents filed with the court, and certainly that are the basis for a judicial ruling, are presumptively public.
Before you get further into that, can you go to the third principle that you were going to say, beyond the common law absent a statute and basis for judicial action?
Yes, Your Honor. And I guess in fairness, number 3 crams 2 together, because the point I wanted to make there was that access to these records is consistent with Section 35 and Section 35A. And I want to go further and say, yes, access to these records is not contrary to the statutory mandates of Corey or recent criminal justice reform.
Okay, well, let's explore that. Imagine the possibility of you winning. It happens sometimes. Roughly 9,000 complaints, there were 9,000 show cause hearings, according to the Globe, each year, where there's a finding of probable cause, but no complaint issues. If you prevail, does that mean that the Globe can basically say, I'd like to see all 9,000 of those documents reflecting a finding of a probable cause, but no complaint?
It would mean, Your Honor, that the presumption is that those records are public, for sure. It would also mean that the clerk magistrates had full authority to rule on whether, in those cases, impoundment is appropriate.
Okay, well, without a motion to impound, without a motion, I mean, they're presumptively public. So somebody would have to file a motion to impound.
As to that, I'd say this, Your Honor. We're talking about the common law powers of this court. So, for example, in the Bishop inquest case, when this court fashioned modified the common law right of access to inquest proceedings, that decision said, because we're exercising our common law powers, we are also going to provide for certain additional safeguards so that these inquest reports are not immediately released before interested parties have a right to be heard. There was a requirement of notice and the like. That is well within the authority of this court in recognizing that there is a common law right here. I would add, too.
So let's play that out. Let's deal with what this decision would mean if you were to prevail. Is there anything that would bar the Globe from saying, I'd like to see all 9,000?
No.
Okay, and would there be anything that would bar anybody else from saying, I'd like to see all 9,000?
Absolutely not.
So any entity which is involved in providing criminal record checks or advising landlords or employers of individuals who've had findings of probable cause against them, they too would be able to gain access to the 9,000.
Gain access, I think, perhaps goes too far. Right now, anyone can ask for those records. This case concerns what standard the clerks and the court should apply in addressing those requests. Secondly,
Well, I mean, clearly they can ask, but right now, you're here because the answer would be no. We're not gonna
the
give them
answer
to you.
would be that under the standards, a requestor would have to demonstrate and carry the burden of proof of demonstrating that it is essentially a unique enough case that public access should be granted. I am saying that standard is incorrect.
Okay, so as far as I can tell, in your world, the world that you're asking us to adopt, anybody could ask for all 9,000 of those records.
And subject to a ruling of the court of
Okay.
whether
Now
they
let's-
should be impounded or
Well,
not.
okay, so let's play that out then. So you're saying that although generally, if it's presumptively public, it's presumptively public unless one of the parties comes forward and moves to impound. Are you saying that the courts or the clerk magistrates or a judge should make a sua sponte decision that would say, no, no one's asked me to impound, but I am going to impound this?
The working group, for example, the trial court's working group, one of its proposals is that clerk magistrates inform participants in those hearings about certain rights, including rights concerning, they didn't use the term impoundment, but public or private access to those records. That is not, I would suggest, an extraordinary new rule to impose on the clerks in this type of a system. The amicus briefs and the clerks have made a point of saying that these clerks, and this I'm sure is true, that these clerks are adept and knowledgeable about the collateral consequences that can come with contact with the criminal justice system. There is no reason to think that that expertise would not be applied in these cases. And if I may back up just a bit on Corey and criminal justice reform, I would submit that none of those reforms operate to deny access at the entry level of a case. They are all designed to limit the shelf life of a public record. So, for example, even in Pond, where a case has proceeded and then been dismissed or null prost, the court did not say the public bears the burden of proving whether that record should continue to be public, notwithstanding the collateral consequences that might come with it. The court said in those cases, case has been dismissed, case has been null prost, the defendant bears the burden of proving good cause.
But complaints have already issued in those cases.
Yes, they have, Your Honor, and
It's a different story, isn't it?
I would respectfully say that if a clerk magistrate has issued a finding of probable cause, it is not a different story.
Well, why is that? It's a very low standard. It's almost nothing.
Well, it's the standard applied in arrests. It's a standard applied essentially in search warrant affidavits. It is, the common law calls for the disclosure of, presumptive disclosure of inquest reports, even though the inquest proceedings are investigatory. There's no right to cross-examination. The presiding officer has
But isn't that
broad
only
discretion.
after, isn't that only after a finding has been made that there will not be a prosecution?
Or that there will.
Or that there will?
Or that there will under the current statute, but the common law provided for that, and that inquest report identifies by name any person who is reasonably believed to have been responsible, either intentionally or by negligence, for the death. So there is precedent for.
Can we stay with this, the hearings, the show cause hearings for a moment? The finding of probable cause, is that required, even if there is evidence of it?
No,
The-
it
so-
is
okay,
not.
So the magistrate does not have to find probable cause, even if there is probable cause?
That's correct, Your Honor.
And there's no relief from that?
That
Not appealable?
it is not appealable by the.
And that would not be something you would know about? Yeah, that's not one of the documents you would be seeking? The findings of
Correct.
probable cause?
That's correct.
Ladies, I mean, if there's probable cause, the magistrate would have to find probable cause. The magistrate has the discretion to not then issue a complaint. that's the subset of documents that you're looking for, is where there's a finding of probable cause, but there's no issuance of a complaint because of the discretion of the clerk magistrate, correct?
True to the last part, I would disagree on the first part. As I read Victory Distributors, a case where the applications for complaints were denied, there was no requirement that the clerk magistrate first make a finding of probable cause. I think that case makes it.
Well, and
You think
if that's the case, then you're asking only for the set of documents and where there's a finding of probable cause, but no issuance of a complaint. And so now you're saying that the clerk magistrate then would just say no probable cause, because even if I find probable cause, you're telling them, well, you can say no probable cause, because that's the same thing as saying I'm not going to issue a complaint.
Right. In other words, you'll win but lose.
Well, to be frank, I have thought that that was a possible outcome from the outset. But the principle that is at issue in this case is if a clerk magistrate or any judicial officer makes a judicial ruling, and I would submit that a finding of probable cause is a significant judicial ruling to which the public is entitled to examine the basis for the decision, period, then in those cases, the situation changes. Now, the amicus say the clerk magistrates have to do this either under the standards or for leverage to resolve the cases.
Have to do this, you mean make a finding of probable?
Make a finding of probable cause.
Otherwise, the clerk magistrate has a nullification ability and can usurp any common law or constitutional right if one exists. You can't have, if there's evidence of probable cause, then there has to be a determination of probable cause.
Your Honor, I would just say that I read Victory Distributors as saying that in that case, the judge and the clerk said, we will not operate and we do not have the resources to operate as a collection agency for supermarkets who are pursuing larceny by check criminal actions. Was there probable cause to support? Did it exist? The case says it may have, but the clerk magistrate was not obligated to issue a complaint.
You know, I was interested to see that some of the forms, one of the forms had a check mark for something that finding of sufficient facts, not probable cause, though. I took that to mean finding of sufficient facts of probable cause, but not a finding of probable cause. Do you get those?
Your Honor, I'm not familiar enough with that, nor is the process open enough for me to be able to have
no,
analyzed
I'm just saying
that.
theoretically, you can have a finding of sufficient facts for probable cause, but not a finding of probable cause, just like finding of sufficient facts in other circumstances.
Well, the principle I am trying to adhere to here is that if a judicial officer makes a judicial ruling and the papers on which the court relies are filed with the court, that the public has a presumptive right of access. And if I may, it seems to me that in terms of the legal analysis that this court has developed over the years, it applies in full force here. The burden that the petitioner needs to overcome, I think realistically, is the argument that principles of criminal justice reform will be obliterated if the relief requested in the petition is granted. And as to that, I would like to say that there is no inconsistency between keeping judicial transparency and accountability with respect to judicial rulings made by a judicial officer that are used as leverage, according to the submissions in this case, to resolve cases. There is no inconsistency between maintaining judicial transparency and judicial accountability for those records and the principles of criminal justice
Let
reform.
me ask you, let's work with that premise and see if the ACLU proposal works nonetheless. So putting aside the constitutional and common law issues, but the issue at stake here, which is to make sure that the public is able to scrutinize what's going on within the judiciary and the need for accountability. Just assume that as a premise. So the public doesn't know much about these clerks' hearings. What if the clerks have to provide the information, the underlying information, comparing Court A to Court B? What's the difference in the result if you have an attorney, if you don't have an attorney? What's the socioeconomic impact? And then as it relates to a case-by-case basis, rely on Uniform Rule of Impoundment Procedure 7B to make a determination on a case-by-case basis whether or not the information should be turned over. Why doesn't that sort of find the sweet spot that allows for accountability but protects the privacy and the implications for those people where a criminal complaint is not going to issue?
I would say, in answer to that is it better than if everything is closed? Of course, I wouldn't quibble with that. But realistically, the idea that people can mobilize the resources to regularly analyze data that is, in effect, a summary of what has happened without the ability to talk to people who are not satisfied with the outcomes of these proceedings. They are forgotten here. Corey says that if you have a criminal record for a certain period of time, certain repositories of that record should be sealed. It says that instead, in the face of statutory mandates permitting discrimination against offenders. It is saying, yes, you can't get your public housing, you can't get your public employment, you can't be licensed by certain agencies, and a host of private entities are permitted under Section 172 to look at your criminal record and make that decision in an employment context. We're not going to fix any of that. What we are going to do is make it harder in certain instances, in many instances, for members of the public to evaluate judicial rulings. There is no need for that conflict here. There is a way to reconcile those two competing principles, and all it requires is recognizing that, yes, as for hundreds of years now, I suppose, a judicial record that is the basis for a judicial ruling is presumptively public. Publishing lists of, there were 8,000 Joseph K's who were processed through the district court, and here's what happened to them, is, I would respectfully submit, not in keeping with the common law right of access that this court has recognized.
But the relief you're seeking cannot accomplish that because you're not asking us to say, open up those proceedings and allow the public to be present for them. And you're not asking us to say, tape record those proceedings and allow the tape recordings to be public. All you're asking for is that some summary document saying PC but no complaint issued be furnished. So how is anybody going to evaluate the merits of that without knowing what the evidence was?
Well, Your Honor, it would be a significant step of progress if these records were presumptively available. There are statements of witnesses at times. The application contains information. Most of these cases, we're told, are brought by the police, so there are police reports. I'm colorblind, so I can't
That's
quite
all right.
tell when
That's all
my
right. You're
time
going
is
to be
out.
here for a while, so don't worry. We'll tell you when you're done. The police, of course, have the opportunity, as does anybody else, to appeal a ruling of no complaint, correct?
The,
The police can go to a judge and say, we were denied the complaint by the magistrate, and we wish now to go to a judge and have you issue a complaint.
the standard, I think, is somewhat less than an appeal.
But you have the
It's
opportunity
a
to go to a
review.
judge. If you're aggrieved by it, if anyone's aggrieved by it, they have the opportunity to go to a judge.
Correct.
Okay, so in terms of the individual who is seeking a complaint and is told, well, yeah, there's probable cause for it, but I'm not going to issue it in my discretion, they have the opportunity to go to a judge and say that you should find differently.
Well, I have to say as to that, Your Honor, when you read the cases and the standards about what that review entails, that's I wouldn't say it's illusory, but it's not a real right of appeal.
So is one of the things we should be doing to make that a real right of appeal?
I'm sure that an unhappy complainant, whether a police officer or a private citizen, would prefer that system. May I add on that? If an officer arrests an individual, making the officer's probable cause determination, and then the case goes to the clerk magistrate, because the clerk magistrate must make a finding of probable cause for a complaint to issue, and the clerk magistrate does not find probable cause, the accused is brought into open court where the accused is then discharged, and the standards say, okay, there's been a finding of probable cause by a police officer. The judicial officer did not make a finding of probable cause, but this person will be transported to an open proceeding where they will be discharged. I mention that because not only are search warrant materials and inquest reports examples of where there is no charge brought, but there is some public aspect to the process that allows for some transparency in that process. And it could be accomplished here if the court acknowledges that in cases where a clerk magistrate makes a judicial ruling, there are ways to fashion remedies that protect individuals who need protecting. But I would say it's a false, respectfully say, because I know these are all sincerely held positions, very sincerely held positions by the amici. But I do think it is a false choice to say we must stop public access to records of judges making judicial rulings because our other laws have not sufficiently addressed the discrimination that occurs to offenders. There would not have been criminal justice reform if we did not have an open judiciary. There will not continue to be criminal justice reforms unless we continue to have an open judiciary. The decisions that these clerk magistrates are making have a significant impact on people's lives. It is a judicial ruling, and the common law has for centuries provided that in those situations, there is indeed a presumptive public right of access.
Can I ask you a practical question? It's been bothering me. Section 35 says if an application for the issuance of a complaint is denied, the clerk is going to have to destroy the documents after 1 year. Does that mean you've got 1 year?
Unless the court orders otherwise, then these records are destroyed after 1 year, which I meant to and I didn't mention earlier, is another reason why the remedy in this case is fair and sensible. Look at what the Corey reform does. It says, okay, these records are open for a period of time, then we're at least going to give a chance for people to seal them. The statute provides a better remedy than Pond provided to defendants whose cases are dismissed or null prost. The statute says that those records are available for a year unless the court orders otherwise.
But isn't your plan to ask for all, I mean, couldn't the Globe just ask for all of the cases in which there was a finding of probable cause but didn't go forward on an ongoing basis, so it wouldn't matter?
Year after year after year, I think all court records, of course, are subject somewhat to that. But as when we talk about on the other side of the scale, practical obscurity, I think we should recognize on that side of the scale that that's quite an expensive and ongoing project to have. And on that point, though, Your Honor, there is, as the articles reported, how was some of this information gathered? Well, some of it was gathered because police reports are public. Some of it was gathered because the state police provided thousands of police reports that allowed people to go back to the district court and see which ones ended up in complaints and which ones did not. I mention that because it is not true that we live in a world where there is no way to find anything out about these proceedings. It is true that the world we live in makes it highly burdensome and expensive to conduct that kind of an inquiry, but it is in that case, a false promise that we will somehow manage if we just keep the clerk magistrate's rulings from the public. We will ensure that the individuals aren't identified. We won't ensure that, but we are sacrificing judicial transparency and accountability.
If we can go back to the scenario which we were discussing in terms of the Globe or a private entity which advises employers and landlords about the criminal records or findings of probable cause of individuals, does what Justice Budd suggests, and every 6 months they make a request. Is it your view that the individual at the time of the show cause hearing would have to move to impound, or that the clerk would have to give notice to all individuals that there's been a request for their records and they have an opportunity to move to impound?
Well, may I answer the question this way? And if I were in charge of fashioning the common law of Massachusetts, I would suggest that clerks could be advised, instructed, that the accused should be aware of the fact that if a finding of probable cause is made, the records are presumptively public. And the clerks can be given guidance about what types of situations in this setting warrant impoundment and what types do not.
Okay, help us, guide us in terms of what that guidance should be. When would there be appropriate cause to impound?
Well, the
Person goes to a youth hockey game and there's a pushing among parents, and one parent comes forward and says he assaulted me. The clerk magistrate says, yeah, he did push you, but it's really not a criminal case. We're not going to proceed. But I find that there was probable cause. Yeah, you did push him, but we're not going to make this a criminal case. Is that good cause for impoundment?
Well, first of all, as any trial judge would say, I would want to know a bit more of the facts about those individuals, but it might be. I want to be as blunt as possible on this. There is an example in one of the amicus briefs about a poor soul who put the wrong license plate on his car, and there was a criminal charge brought. Well, I don't think that's a tough case on whether, I don't understand why a finding of probable cause had to be made, but if the clerk magistrate felt impelled to make a finding of probable cause in that case, then, I don't see why that case would not satisfy the impoundment standards, assuming that well, I don't see why it wouldn't. There are cases that are not so close,
Okay,
right? There are.
I just gave you a case, and very often a clerk magistrate may know nothing more. They don't delve into the lives of each of the persons in great depth. These are hearings about a youth hockey game, and somebody says he did this, and they go back and forth, and arguably they may say, let's see if we can resolve this as colleagues and resolve it. But I do find probable cause. Is that going to be, we don't know. You're going to need to explore whether you own a home or whether or not you may, in the future, be looking for a job. How is a clerk magistrate supposed to decide that on the spot as to whether
Was there
there's...
an injury?
No?
Was there, well, these are all factors that would lead in
Okay,
favor
well, help me.
of. Well-
Would help me to understand what you consider to be just cause to impound in those circumstances.
I would say this. I would look at the Rule 7 of the Uniform Rules of Impoundment Procedure, which require me to take into account the extent of community interest in this incident and a variety of other factors, any privacy interests involved. And I would, if you were appointing me momentarily as that clerk magistrate, I'd probably impound that record. I would come out differently.
And why is that? There's a finding of probable cause of an assault and battery.
Well, because if the assault and battery was a brushing with no injury, I think the court would have discretion to make that determination.
Isn't that the same determination the clerk magistrate made in deciding not to have the complaint go forward?
I
Can it be
think
moved
not,
back a little
Your
bit?
Honor. I think not. You sorry?
I mean, that was what my questions were alluding to before. If you don't have to find probable cause, if there is probable cause. So here, there is probable cause, I suppose, legally, but the clerk magistrate chooses not to find probable cause. And then there's nothing for you to get.
If there is no finding of probable cause.
Why wouldn't clerks hold the finding of probable cause over people's heads as threat of prosecution? Move it back a step so that you can't get any of these documents.
It is possible, I try to acknowledge this, that a clerk magistrate could say, if this petition is granted, if the relief is granted, a clerk magistrate would say, well, I'm certainly not going to make a finding of probable cause. The record might come out. That is a possible outcome.
Yeah.
Still, the situation we have today is, and the record indicates without dispute, that clerk magistrates make findings of probable cause for leverage. And I do respectfully submit that that is a situation that justifies public access to the record. We don't know if that leverage is being used fairly. We don't know if there was a basis for the clerk magistrate obtaining that leverage. And I would submit that in those situations, the common law right applies.
So you would
Isn't
deny because the public has entitlement to know that after all, we made some resolution with regard to it, that therefore you would deny the impoundment in the example that I give. I'm trying to figure out what you're sort of all over the place in terms of what you consider to be justly impounded. And you're asking us to apply a standard, but you appear to be a little bit queasy about that assault and battery being made available to the public, and I'm trying to figure out why, and because that queasiness arguably is a reason to say, well, those are precisely the type of cases which should not be made available to the public generally. So I'm trying to get a handle as to how you separate out your view that these generally should be made public versus those cases where you say, well, it's really, I mean, yes, there was a push, but it's not the kind of stuff that we want somebody to be labeled an individual who's involved in assault and battery. So when they apply for a job, they'll be viewed as violent. When they apply for housing, they'll be viewed as somebody who is been found to have engaged in assault and battery. I'm trying to figure out.
Let me try, if I may, I'll try again. Because I don't mean to be waffling on it. My view of the way the impoundment rules would operate is that a clerk magistrate would be entitled to take into account the facts and circumstances of the particular case in determining it. If two people brushed up against each other and a charge of assault and battery
It's not a
was
brush, it's a
brought,
push. They were teed off at one of the kids doing something. It happens all the time, I'm sorry to say. So yeah, it's a push. It's really a push. It's not a flick, it's a push. It's an assault and battery. It would be an assault and battery. But the person's exercised some judgment to say, we're not going to bring every time a parent pushes somebody at a hockey game, we're not going to bring them into court and say you're committed a crime. And that happens a lot. We see, I mean, I've seen some share of these complaints. I go to courts and I ask to look at them, and that's neighbors getting involved in these kind of things. That's a pretty typical dispute where there is some degree of, there is a crime purportedly committed. But the question is, do we really want it to go forward as a crime?
I am not answering a question with a question. It will sound like it at first. But whatever the outcome of that case, when a woman comes in with a tape recording of her boyfriend assaulting her, a different standard should apply. I do not know how, as I stand here today, to resolve
Perhaps that's
every
a statutory issue in terms of gradations of assault and batteries. We could have a first-degree assault and battery and a second-degree. I mean, maybe there's a need for legislative change there.
Yes, for sure, Your Honor, but in the meantime, there is the system that continues to operate in our communities.
Can we get back to that analogy? And I just want to see if this takes you where you want to go or what the scenario is. So the chief posits this hockey game push where they jar into each other, one person pushes the other person. I assume that the Globe's interest and your interest would be if the connected lawyer comes in all the time in front of the clerk magistrate and all of her clients seem to get no complaints issued, you'd want to know that, right?
That's true, Your Honor.
That's the issue of the secret courts and the like. But if how does that work in the real world where under your system the magistrate has the ability to just impound these things with the connected lawyer?
Well, we are depending upon the clerk magistrate to make a fair and reasonable ruling on the impoundment issue. As in all of these cases, there is a fair amount of discretion afforded to judicial officers, and we do depend on that. That is the system, right? The answer isn't, sorry.
There's certainly a distinction between someone who's given a break and the magistrate says, you know what, I'm gonna find probable cause, but I want you to come back in 2 months. I want you to apologize, keep your nose clean, do some community service, and we'll see you in a month. That's one scenario. The other scenario, as you may posit, is, well, the lawyer who's my buddy just represents him, so no complaint's going to issue. How do we distinguish between those?
The only way to distinguish between them, I hope this is answering your question, we can't now because there's no access to these records. And the only recognized way that the petitioner could come up with to improve that situation is the common law right subject to the right of impoundment. And you're right, Your Honor, that, I don't mean you're right, but the premise of the question is correct, that it will not be a cure-all. There will be cases that are impounded that should not be impounded. I have to admit, there'd be cases that won't be impounded that maybe should be impounded. But that is the way all of the courts are operating in the Commonwealth today. And I am here to say that if a probable cause finding is made, in these cases, many brought by police, many involving non-trivial felonies, that a system that says those rulings are not subject to any transparency is inconsistent with the common law, and I think contrary to the prior decisions of this court involving search warrants, inquests, and other types of probable cause hearings. And I wish I could more clearly articulate that the principles of Corey and the principles of criminal justice reform do not require that the courthouse doors at the outset of a case be shut. That's not what they have, that's not what those
How do you define the
advocates have
outset of a
made.
case? I guess that's one of the things that I'm curious about. How do you define the outset of a case? You say at the outset of a case. What is that?
Well, I more
Is that when a criminal
precisely,
charge is brought? It's not when a criminal charge is brought. It's earlier than that.
no, it's when in a search warrant situation, when there has been a finding of probable cause and the materials are returned and filed with the court. In an inquest, it's when the inquest report is filed with the court. And in this situation, it's when a finding of probable cause is made, and those records are indeed on file with the court.
So you want to move it back. Right now, it is when a complaint is filed. That is the position that the trial court has taken.
That is definitely the position
And
the
that's
trial
what's
court
been in
has
effect.
taken.
Right?
Yes, that's the basis
That's when the case begins
for
according
the
to the trial
petition.
court. That's when the case begins according to the trial court.
Correct,
Right.
correct.
Yeah.
And in the search warrant situation, there may never be a criminal charge. There certainly isn't a criminal charge when the search warrant materials are released to the public, and the same with respect to the inquest. There is no criminal charge. There has been judicial action, and a document has been filed with the court.
So you see no distinction between filed and received?
It's
That's purely semantics.
It is. The statute talks of filed, says the applications are to be destroyed 1 year after they are filed. The complaint standards say the applications must be filed. And in Victory Distributors, this court interpreted the received language of Section 35A to mean the application has been filed.
So what papers would you get? Would you get the applications?
Yes, yes.
Why?
Your Honor.
Because the case hasn't started yet, according to you. According to you, the case doesn't start until there's probable cause. So is it the probable cause determination going forward that you get the documents for?
If the clerk magistrate has made a finding of probable cause based in part on the application, then yes, I do say that application is presumptively public.
Okay.
Not until,
No, I understand it, but you want to go backwards from the time that the case begins. Because you say the case begins with the finding of probable cause, not with the application, not with the hearing itself.
yes, Your Honor, and I think the analogy there is no member of the public can attend a proceeding
Right.
where a search warrant application is made, but once the ruling is made and the materials are filed with the court, that document is public. So to here, I'd say until there is a judicial ruling on that application, it is not public, but once there is
Goes
a
all the way
judicial
back.
ruling, it is public.
But a finding of no probable cause is also filed. Correct?
Yes.
And I don't understand why you say that it becomes a presumptive record only if there's a finding of probable cause, but not if there is no finding of probable cause. Both are filed, both are decisions by a clerk magistrate.
Well,
That's the next
Eagle
case.
Tribune says what Eagle Tribune says, and
I think we
this
can, I think we
court,
can agree upon that.
and this court, perhaps the first time today, the common, what I meant by that is that the argument that is made in this case is consistent with the common law rulings that the court set out in Eagle Tribune. And I would submit that it would not be consistent with the common law rulings that the court set out in Eagle Tribune.
Where did
For a
it set out, where did
litigant.
it set out common law rulings in Eagle Tribune?
Well, it said there's no, fair point, rejected the First Amendment
Right, that's exactly
argument. But I think it's fair to say, how can I say this?
It certainly described the process.
Yes. And as a litigant before this court, I read Eagle Tribune, and I, as any litigant must, and make a judgment about what is consistent with that case and what is not consistent with that case. And to say that if you don't find probable cause, it's open, and if you do find probable cause, it's open, seems to me to be inconsistent with what the court held in Eagle Tribune. Forgive me, but I find
Is
no.
there any room for a distinction between complaints that are brought by police and complaints that are filed by regular people?
I think
Like your neighbor, your next door neighbor.
I recognize the distinction, Your Honor, but I think in terms of whether the public should have access, I would suggest no, because while, yes, the folklore is that the village elder is resolving the hockey dispute or the neighbor dispute, the private citizen complaints also can be of very serious matters and therefore also are subject to the common law rule. I do think that the gravity of the offense is a relevant consideration under the Uniform Rules on Impoundment Procedure, even if I have failed
Really?
to answer.
We don't generally
the
permit
question.
impoundment for assault and batteries going forward. It's usually based on something far more than the severity of the offense.
May I say it this way? The court will be fashioning a common law remedy that will improve a situation where there are judicial rulings made that the public is prohibited from viewing. I would suggest that the court has common law powers to fashion that remedy in a way that is consistent and appropriate to the nature of the proceeding. We are talking about a common law presumption, just as the court did in the Amy Bishop inquest case, setting out different procedures because of the unique circumstances. But the answer is, I say, is not, we must keep all these rulings private.
Okay, thank you. Now you're done. Thank you. Mr. Haskell.
Thank you, Your Honor, and may it please the Court. The relief that the Globe is asking this Court to issue here not only is inconsistent with this Court's precedent, it's also inconsistent with several attributes of Section 35A hearings that make those hearings what they are. In particular, the fact that they are preliminary to and outside of the criminal prosecution process, which of course begins and sees its outset only when a charge is filed in court. And second, that the 35A hearing exists to benefit the accused by giving them the opportunity to stay out of court and stay out of the criminal justice process, including all of the effects that come along with being involved in the criminal justice process in court. I think in order to see why this is true, one needs to take a broad perspective of the criminal procedure, the charging processes in Massachusetts, and particularly some anomalies, some unique features of the process in Massachusetts that explain why we have the Section 35A statute and the Section 35A hearings that we do. One really unique thing about criminal charging in Massachusetts is that it is not the exclusive province of the prosecutor, as it is in nearly any other state. Complaints can be brought by anybody. Commonly, they're brought by law enforcement. Not infrequently, they're brought by private citizens. And it's not the prosecutor who has exclusive authority to decide whether that charge is going to go forward. At least in the first instance, where Section 35A applies, it goes to a member of the court system, a clerk magistrate and/or a judge. Only then does the prosecutor's discretion get involved. I think these features.
Prosecutors, I'm sorry, I didn't understand. How does the prosecutor's discretion get involved at that point?
So the discretion that a magistrate or a judge reviewing a magistrate's decision in Section 35A has to decline to issue a complaint.
So you're
is
talking about the
supported
clerk
by-
magistrate, not the prosecutor's office.
Well, initially, if the magistrate exercises that discretion, the prosecutor has effectively the ability to override it and say that if there is probable cause and all the other legal aspects of the complaint are in order, we want to prosecute this, and the district attorney has the right to do that. I think that feature of Section 35A goes to show and really illuminate how these hearings are not adjudicatory in nature. They're accusatory in nature, and that's a distinction that I think this court recognized in Eagle Tribune when it drew a strong analogy between show cause hearings and the grand jury, which likewise is accusatory, not adjudicatory in nature. I think
But
that
the clerk
is,
magistrate does have, by statute, the word is, if you find probable cause, you may issue a complaint. So there is a degree of discretion, which is what Mr. Albano is arguing, is that where there's a finding of probable cause, but the discretion of the magistrate is exercised to not issue a complaint, he says that essentially is an adjudicatory judgment, and that should be reviewed by the public.
and Your Honor, we don't agree with that. In our view, it's not adjudicatory, it's accusatory, in part because it's preliminary to the point that this court has repeatedly recognized is the outset of the criminal process, that is the public filing of the charge, because it's reviewable and can be overridden by the district attorney, and also because it only operates in one direction. What I'm getting at there is under the relief that the Globe is seeking, the public would have access to a situation where the clerk magistrate has found probable cause but declined to issue the complaint. The whole world is going to see what the accusation was, how the magistrate handled it, and what happened there. One of the fundamental problems with that is it puts the accused in a situation where this is going to be publicized, everybody's going to know about it, but they have no opportunity to exonerate themselves. They have no opportunity to put the prosecution to its proof and to beat the charge. And that's why the relief that the Globe is seeking here is particularly troubling from this criminal justice perspective.
Could I interrupt you for a minute
Absolutely.
and ask you about, you mentioned that, I take it your premise is that if you can't have access to the proceeding, you can't have access to the documents concerning the proceeding. Is that true?
That's right, Your Honor.
Is that right?
Yes, it is.
Is that true about the way common law has worked?
So
In terms of judicial documents, there are things that you don't have a right to access yourself to attend, and yet you can get documents about them, like the inquest.
So inquest is the inquest is a kind of unique example because it's largely controlled by statute and the
Well,
legislature.
so is this.
The judgment that the legislature made in Section 35, I think is what you're referring to, certainly plays a big role here. And if this court agrees that the legislature in Section 35 has spoken to public access to records of hearings of this type, then that's the ballgame for the common law argument. If the legislature has spoken to it, then the legislature has said what it said.
So that's the ballgame. In other words, there's no superintendent's ability for us to come up with something that allows the public to understand what's going on in the clerk's hearings, but doesn't have those who have an accusation and a criminal complaint doesn't issue, have them have some layer of protection.
I'm sorry, what are you
Section
getting at with that
35
last?
is dispositive of our ability to address this issue as far as superintendents?
It's dispositive of the Globe's claim that there's a common law right of access to records of the type that it's describing. This court, of course, has superintendent's authority under 211.3 to, well, to superintend the mechanisms that exceptions can be made to a common law principle of non-presumptive
I'm
access.
just wondering if your argument about Section 35 abrogating any common law here proves too much. That's my point.
Well, Your Honor, what I would say to that is that both the common law right of public access to court records, as well as the First Amendment right of public access to court records, isn't absolute. And in this situation, as we describe in our brief, even though there is no common law presumption of public access to these kinds of records, there are ways to get them, and there are ways to get at them.
But that
We
is the
describe-
point, that is the point, though. Is there a common law right to have the access to the documents? And how do we decide that? I mean, on the basis of they're not judicial records?
I think there are two ways that this court could decide that issue in favor of not finding a common law presumption of public access, and they're independent of one another. One is what you just mentioned, that they're judicial records, that they're really outside of the scope of the types of records to which public access can be presumed. Winfield is really the key case on that, where this court drew a distinction between judicial records that appear in a public case file and those that don't. The analysis is
Well,
different.
okay, let's go back to the inquest then, and the what was the other one? The inquest and the well, it doesn't matter.
Bishop was the inquest, and Winfield was the court reporter's tape recording, I believe, correct?
Yeah.
That's right. The backup recording, that's right.
But in the inquest, you're not entitled to the documents until the inquest is done, right?
Until the
But you get the records, though.
until the district attorney makes the finding that they won't prosecute, it's filed in court, or alternatively, that they do go forward with
Are you
charge.
saying that the documents here are not filed in court?
I think filed in court is, it's a shorthand that this court has occasionally used. I think it's an ambiguous and maybe confusing shorthand. I think the correct line is what this court pointed to in Winfield, where it made a distinction between documents that are filed in a public file on a case, Smith versus Jones, versus judicial records that are not. I think things can be filed in court even when they aren't filed in a public case file. A good example is an application for a search warrant. When a police officer goes to the court with an application and an affidavit for a search warrant, gives it to the clerk magistrate, gives it to a judge, asks them to issue the search warrant, are they filing it in court at that point? I think in some respects they are, but those documents don't become public until after the PC finding, the search warrant is returned, and the return and the application go into a case file with a docket number. That's where the line is drawn for search warrants, not at the PC finding, at filing it in court.
Because there's no criminal charge brought.
In the case of a
Search warrant.
I think the way this court has treated search warrants, whether it matures into a criminal charge, doesn't affect the analysis about public access to those documents. And I believe what this court has said is that because people's property is at issue and kind of a different set of rights, that the public ought to see search warrants regardless of whether search warrants that are returned to court, regardless of whether they result in any criminal charges being brought.
How about 209A affidavits? Isn't there a right of access to 209A affidavits even if the restraining order is denied? And doesn't that raise many of the same issues?
My memory, Your Honor, is that portions of the 209A affidavit are not publicly accessible by statute. Other portions of them have been deemed accessible. I think what's different about this situation is an allegation and a finding of probable cause that a crime was committed. Publicizing that kind of information creates what one of the amicus briefs I think aptly described as a quasi-criminal record. It's going to have the same pernicious effects that a criminal record has, but it's not going to be subject to the limitations that come with being charged with a crime, with information about having been charged with a crime, like the ability to beat the charge and to get acquitted, or like the ability to go back and seal it under statute. And so I think earlier, Justice Lank, I was responding to your question saying that there are two ways that this court can reach the conclusion that there is no presumption, common law presumption of public access to these records. One is finding that the records are beyond the scope of the type of records to which that common law doctrine applies. The other is to find that the legislature has already spoken to this. And in Section 35, they have spoken to this. They've legislated against a background that says that all public criminal case files are open to the public and are open to the public for 10 or 20 or more years, depending on the case. And the legislature has, in Section 35, decreed that these particular types of records that do not result in issuance of a criminal complaint only get retained for 1 year and are kept in a separate place, which is a mechanism, it's a formulation that has been used in other contexts to signify that the public won't have access to them. So either of those avenues, I think, get this court to the conclusion that there is no common law presumption of access to these records, either legislative, Section 35, or the principle that these records are outside of the scope.
Have we any statutory history, legislative history on as to 35 and 35A?
I'm not aware of it, Your Honor.
Now, 35 precedes 35A considerably in time, right?
Yes, that's right.
35 was around since 1852.
That's right.
1853.
35A was enacted in the early 1940s.
1846. Yeah.
So I asked Mr. Albano what would happen if he were to win.
43.
I'm going to ask you the same question. There is a concern, appropriately, about transparency with regard to the decisions made by any judicial officer, judge or clerk. Is there not a need for some degree of accountability on the part of a magistrate making these decisions? And what, if we were to find in your favor, how should we exercise our superintendent's authority to ensure some degree of accountability?
Those are very legitimate concerns, Your Honor. The Globe has raised them through its reporting over the past 6 months, and the trial court takes them very seriously. And as the court knows from our briefing, the trial court convened a working group to do at least the beginning of a top-to-bottom review of this system and how it can work better and how it can better address these legitimate concerns about transparency and accountability and assuring the public that nobody's getting special treatment here. The report of the working group identified several future steps to be taken, including revising the district court standards, including really beefing up the standards for when a particular show cause hearing is found to be in the public interest, to expose it to the public and to make it accessible to the public.
How do you know when it's in the public interest? Lots of things happen, and then 3 weeks later, it's in the public eye. So how is the magistrate supposed to know that?
I think the start is the standards, the considerations that the district court standards document lays out. And what they focus on are the nature and the seriousness of the allegation, as well as the strength of the evidence supporting it. They also focus on whether the accused is a public official, and not just that they're a public official means that the public ought to see it, but a public official who is accused of abusing their office or abusing the public trust is the kind of thing that is in the public interest to air and to see. And another consideration there is whether the allegations are already out in the public, whether they've been reported and been publicized.
And the working group deferred to this decision on the issue of tape recording or recording?
Yes, that's right.
What's your position on that?
Your Honor, recording is, going back to the Chief Justice's question about superintendent's authority, I think ordering these types of hearings to be recorded is well within this court's authority. This court did the same thing in Grassy a couple of years ago.
In Grassy, but,
Grand jury context.
yeah.
In the grand jury
context.
context.
But anyway, what's the argument against tape recording?
Your Honor, it's really a policy decision.
I guess I'll ask you straight out, what's your position on this?
Our position is that the trial court is taking that issue seriously and ought to be allowed to have the first crack at it in terms of determining a policy.
Okay, you had that chance in the working group, and you said you're going to defer to us. What's your position on it?
Again, Your Honor, the trial court's position is that
I guess you're not going to give me a yes or no?
I'm afraid I'm not able to, Your Honor.
The working group spoke about one element of accountability is the possibility of an appeal. And I believe the working group said that individuals should be informed at the conclusion of that hearing that they have the opportunity to appeal to a judge, correct?
That's right.
How is a judge supposed to adjudicate that appeal if there is no record of what transpired below?
Well, first, when an aggrieved complainant presents or re-presents the allegations to a judge, the judge has discretion about how to handle that. Sometimes, and my understanding is that this is done commonly, sometimes the judge will just look at the papers, and those papers at a minimum will consist of the application for issuance of the criminal complaint as well as the findings that the clerk magistrate made in the first instance. The judge also has discretion to hear directly from the parties, from the complainant and the accused. My understanding is that sometimes, at least occasionally, a judge will go that route. And so there's some flexibility which I think we would expect the judge who's doing that redetermination exercises some discretion in terms of the best way to make that redetermination on the papers, hear from the parties, or
That happened in a closed courtroom?
So I'm not sure that the practice is consistent on that, Your Honor. Because the redetermination is still part of the show cause, part of the Section 35A process, it's not, at least as the law stands right now, it's not presumably accessible to the public. I'm going outside of the record here, but anecdotally, you will occasionally see a judge do it in a public courtroom, and I'm not sure that the practice is consistent across all of the
Although the practice
different
isn't
branches.
consistent across the clerks. Some clerks record, some clerks don't.
That's right. Right now, about a third of the district courts.
Shouldn't we have one rule? Will you give me that?
Your Honor, as I stand here today, it's hard to envision a reason why not to record these hearings. I think the trial court's position, though, is that a policy decision like this, they're in the best position to evaluate all of the circumstances and to take guidance that this court is going to pass down when it...
When you say that, are you suggesting that they could or could not record the hearings depending on their particular view at the moment?
I'm sorry, as things stand
Of the
right
clerk
now, or-
magistrate, like, would the clerk, are you suggesting they should have the option of not recording them on a case-by-case basis?
No, I don't think I'm suggesting that, Your Honor. What I'm suggesting is that in terms of setting a uniform policy for the district courts, that the Chief Justice of the trial court, the Chief Justice of the district court are in the best position to set that policy in the first instance with guidance from this court in the opinion that's going to come down. And in saying that, let me reiterate that there are a lot of good reasons to do that, and the trial court is mindful of those good reasons.
You mentioned the possibility of an appeal. Generally, for an appeal, we don't have a new evidentiary hearing. We already had one. We just read the transcript or we listen to it. judges in the Superior Court have the opportunity to do a de novo review of a 58A determination for dangerousness, but when I used to do it, they would give me a transcript of the underlying hearing. I wouldn't say, okay, let's do it again. Why should it be different in the context of a show cause hearing? If the court is going to say that one of the ways in which you have accountability is the opportunity for each party to be able to say, I'm unhappy with this result, I'm going to go to a judge and review it, why should that judge not be in the position that that appellate judges or even Superior Court judges who have de novo review, the position of saying, I'm going to listen to the evidence at the hearing and I'm going to render a decision?
And I think the answer to that, Your Honor, lies at least partially in the fact that a judge taking a second look at a clerk magistrate's choice to deny issuance of a complaint isn't an appeal. It's a redetermination that goes back to this court's decision in Bradford versus Knights.
So it's a de novo appeal.
That's right. That's right. It's
Okay,
a second set of eyes.
Which is 58A.
And so
Which is, as Justice Gaziano said too quietly for you perhaps to hear, that's the same thing we do in a 58A hearing. It's a de novo review. It's essentially a de novo appeal.
And I think, Chief Justice Gantz, you have identified one of the good reasons why perhaps clerk magistrate conducted 35A hearings ought to be recorded. That's right. That's right.
Mr. Haskell, I'm going to ask you about the ACLU proposal as you sit here representing the Chief Justice of the trial court and the district court. So all these concerns raised by the Globe are legitimate as it relates to court by court issues of poverty and race and the impact of that. What's the impact of cross complaints and sometimes the clerk's hearing being used as a weapon by individuals or litigants when the law enforcement would never have any reason to know about the issue. So there's all of these really legitimate concerns. The impact of an attorney and ACLU proposal as well. Let's just get the statistics out, the information out, but protect the individual's name so we can have that type of scrutiny and at the same time protect individuals who haven't been actually charged with a crime. Does the trial court have the ability to be able to execute what the ACLU brief suggests?
So the approach that the ACLU suggests, the trial court in general is in broad agreement with. This is the kind of data that's currently available, subject to Trial Court Rule 14. We speak a bit about it towards the end of our brief. What I would caution this court on is the specific data points that the ACLU proposes in their brief. My understanding is that not all of them are being collected right now. Many of them are, I think most of them are, but their
Could we require them to be? Could we require them to be collected?
As an exercise of superintendence, yes, this court certainly could. What I would encourage this court just to be mindful of is the technical aspects of it, and that anything that the ACLU proposes or that this court orders is going to have to be implemented both at the level of the mass courts system and making it compatible and able to do this, and then at the level of individual clerk magistrates and assistant clerk magistrates who are going to have to input that data.
So here's one issue that's, that I think is important. They all are, but the impact of an attorney, because there's no right to counsel at a 35A hearing. And so there's the possibility of a disparate impact on people who might not have the same means as others. And maybe there is no impact, maybe there is, but the impact of an attorney in the 35A hearing when the other individual doesn't have one, is that the type of information that could be gathered and provided?
It's the type that could be, yes. My understanding is that currently it's done, maybe not fully consistently. But this goes to one of the recommendations of the working group, which is to tighten up both mass courts and the forms that correspond with mass courts, and the training that's given to clerk magistrates and assistant clerk magistrates in terms of record keeping about this sort of thing. The trial court shares that concern, Your Honor, about the effect that the presence of counsel has, and that's something that the trial court looks forward to working with as it implements the recommendations of the working group around data keeping and the visibility that good data keeping gives to the public on the operation of this system as a whole.
Well, could you be a little bit more practically oriented here? How is it that we could determine, for example, if a lawyer in particular was, really getting relief for his clients that seems to be statistically unlikely, other than having a friendship or something like that with the clerk magistrate? How would we determine that, and based on what the trial court working group is doing?
I think the way to get an understanding of that would be first to ensure that data is collected about the appearance of counsel and who that counsel is, and then to make that data available in a way that allows the counsel to be identified and basically their win-loss record to be evaluated. A note of caution that I would sound on that is I think we all would agree that it would be important that if the idea of this data is not to identify the accused, you wouldn't want to do that in a way that inadvertently identifies the accused. And that's part of where I'm coming from when I say that a policy decision of this granularity respectfully is something that the trial court and the district court are well equipped to take a run at least in the first instance.
What if we attempted to accommodate the concerns that Mr. Albino raises and the concerns that the amicus raise with regard to the unfair consequence, and address the potential of good cause reasons to impound by simply saying that the document should be, that the names or identifying information should simply be stricken from, there should be a clean document and then a redacted document, and the redacted document will be made public.
The redacted document just omitting the name of the accused, the
Name or
identifying
the address
information.
or the information which would clearly identify the accused, but primarily the name.
Well, and I think one practical hurdle that would emerge to that, Your Honor, is that the nature of the allegation itself, what the applicant writes down in the application for a criminal complaint, might serve to identify both
Well,
that
potentially,
person.
but I mean, if we're concerned about the mass request for these and the agency which is going to ask for all 9,000 and then be able to tell individuals, they're not going to be able to go back in and say, oh, okay, well, at the hockey fight that I mentioned, this person is from Danvers, and I think it's probably this person because this person uses this individual as counsel. I mean, if you redact the names, you accomplish 98% of the purpose of protecting those individuals from the misuse of that information.
Well, and right now, that's essentially what Trial Court Rule 14 does, is doesn't publicize the name, the address, the demographic information about the accused, but also doesn't publicize the allegation itself. I think that would be the marginal step that you're describing.
I'm confused by what you say, Rule.
Sure.
I should know what Rule 14 says, but I don't in this context. Which Rule 14 are you referring to?
Trial Court Rule 14, I'm
Okay,
sorry.
Which says?
That's the rule around public access to compiled data.
This is not compiled data. This would be literally each time a clerk magistrate prepares a report, he would write the findings, and then there would be a copy made with redactions made, and then there would be a public file, which would be a redacted file, and a non-public file, which would be an unredacted file. And the redacted file would include the same information, but would omit the name.
Your Honor, I think a lot of that information is already available, again, through the compiled data process, through Trial Court Rule 14. I would be...
Really? I mean, again, going back to my example, you think the report of the clerk magistrate would be available, say, to the Globe or somebody else who is looking to see whether or not there are issues with regard to the adjudication of these matters?
And I'm afraid, Your Honor, it depends on what you mean when you say the report of the clerk magistrate.
Clerk magistrate,
That's the level.
the report that Mr. Albano is seeking is essentially the findings made by the clerk magistrate. I guess he's also seeking the complaint or so that there would be an issue there. But put that aside. I'm speaking only about the findings made by the clerk magistrate. Any reason why that could not be redacted and put into a public file?
That data, at least the outcome, the finding made by the clerk magistrate, is currently available. As a matter of fact, the Globe received a lot of it preliminary to doing its reporting and filing. In this case, it's what enabled it to do the reporting that it did around rates of issuance at different courthouses. The data they received also included gender and race information of the accused as well. So that kind of thing, in large part, already is available. To the extent that that there's a policy decision to be made to go beyond that, I wonder at what point that policy decision starts to bump up against Section 35 and the decision that the legislature has made that applications that don't result in issuance of a complaint shall be marked no complaint, kept in a separate place, and not accessible to the public.
And destroyed.
And destroyed after 1 year. That's right. That's right.
So that might be a problem with the sort of anonymized version, because that would not get destroyed if it was in a public file?
I'm sorry.
That would not get destroyed because it would not be in a public, it would be in a public file, it'd be different, the anonymized version.
I think that's right, but it's really all going to come down to the details, which, again, is a big part of where I'm coming from when I suggest that the trial court and the district court administrative offices might be in the best position to take a run at this in the first place. They really know the details, they know the ins and outs, they know the mass court system and its limitations, and as the report of the working group reveals, they're very attuned to and they take very seriously the concerns that motivate us to be here today.
So if you were to, if I were to say that more directly than you did, I mean, we're not going to be able to understand what's going on in the actual district court and what the implications are if we're trying to systemically come up with a model for what's best of balancing individual liberty and accountability. That's what you're saying.
Yes, Your Honor. I'm saying...
You just said it nice.
Thank you, Your Honor.
Yeah.
All right, thank you.
Thank you.
Mr. Haley, thank you for your patience.
Good morning, Your Honors. Peter Haley for the Association of Magistrates and Assistant Clerks. I appreciate the court's courtesy in allowing me to address the court this morning. I'd also like to thank the other parties who filed amicus briefs in this case, notably the Harvard Defenders, Greater Boston Legal Services, the American Civil Liberties Union of Massachusetts, together with the Massachusetts Law Reform Institute, each of which have informed my understanding of these matters greatly from their day-to-day appearance in the court in these hearings, and has spoken eloquently to the effectiveness of 35A as a tool in the district courts as it adjudicates disputes between the citizens who appear before it. In its petition to this case, in paragraph 9 of that petition, the Globe alleged that the 2008 standards seem to have affected a change in the way in which 35A hearings were conducted. That allegation seems to appear to address specifically the fact that this court, absent some change, has already decided this issue in Eagle Tribune in 2007, in which the court considered all of the issues that are advanced by the petitioner this morning and determined that one, there was no history of openness with respect to these proceedings, and two, that openness was neither necessary nor effective with respect to the conduct of these proceedings. The allegation that the 2008 standards somehow affected a change is incorrect. The citation in paragraph 9 is to Commonwealth versus the juvenile court clerk in Boston. In that case, the 2000 case by this court, the court held that it was not within the power of the clerk magistrate to continue a complaint absent the assent of the Commonwealth, the police, if they were the prosecuting party, or the complainant. That decision was also cited in the 2008 standards itself at page 113, in which the 2008 standards indicated that that was still an effective decision. It remains a decision which is observed by the clerk magistrates today. There has been
I'm sorry, you say that, but to my knowledge, the standards have been endorsed only by the district court and not yet by the BMC, correct?
The standards have been, the 2008 standards promulgated by the district court by Justice Connolly. However, the standards, especially with respect to that decision and each of the 5 decisions that this court has issued, are observed by the clerk magistrates. The court's decision, clerk magistrates would...
I know that our decisions, I certainly hope that our decisions are observed by all the magistrates, but I'm asking about the standards themselves. They are district court standards. Has the BMC, to your knowledge, endorsed those and say they are now district court and BMC standards?
I don't believe that they've officially endorsed them, Your Honor. However, I believe that they are observed, and obviously the standards, as indicated in the prefatory statements to those standards, are qualitative standards. They don't affect a change in the statute or otherwise create any statute, but they are guides to the use of 35A, and I'm not aware of any provisions of those standards that are not observed by the Boston Municipal Court or within the Boston Municipal Court system. With respect to the court's decisions in this matter, they have been remarkably consistent. The court, in 1943, the legislature enacted the statute. There were standards that were promulgated in 1975 and in 2008, and as the trial court has indicated, the working group, as set forth in the supplemental record appendix, is in the midst of another review of those standards at this time. In 1998, the court addressed this matter in Bradford, holding that a party who a clerk magistrate found did not commit the crime that was alleged by the complainant did not have a right to appeal the adverse decision of a district court judge. Similarly, in Victory, in that case, another case where the district court acted as a de novo review party and found that there was no reason for the issuance of a complaint.
Can I ask you about the Victory Distributors?
Yes, Your Honor.
Does Victory Distributors stand for the proposition that if at the 35A hearing, the clerk magistrate believes that there's probable cause, that nonetheless the clerk magistrate does not have to find probable cause?
I don't believe it does, Your Honor. In Victory, there was no hearing. The first application in the Air District Court, the clerk simply said, we're not going to process these complaints, and used the clerk magistrate's discretion not to issue the complaints. That then proceeded to the district court judge in Air, and the district court judge concurred and would not issue the complaint. In Marlborough, a letter was sent to the district court judge, and this court's decision in Victory held that the court's, in essence, failure to act on that letter constituted its own determination there.
Right.
But
Thank you.
but just to be clear, you agree that a clerk magistrate has the authority, after he or she finds probable cause, to decide I'm not going to issue the complaint?
I agree that the clerk magistrate has that authority in the instance where the Commonwealth doesn't otherwise elect to proceed to bring the complaint directly, as it certainly has the ability to do.
Of course it has that ability, but I'm referring to situations where they have, where it's a misdemeanor and it's a complainant is a private person, or in a felony context where the police say, no, let's bring it before a clerk magistrate.
The practice, Your Honor, is much similar to the court's 2000 decision, which is simply that if and using the court's hockey game analogy, The other party says, you've assaulted me. The clerk finds, yes, that did happen. The other party admits that they made the assault. The party that was struck says, and I had to get my jacket dry cleaned. And the clerk says, you know what? Why don't you pay him $25 for the dry cleaning? We'll hold this in abeyance for 90 days. And if I receive evidence that that's taken place, we'll dismiss the complaint. The clerk magistrate certainly has that authority. However, that's almost always premised on the complainant, in which the clerk magistrate seeks the input of the complainant agreeing to that resolution, which is the way in which the matters are resolved. The clerk magistrate would technically have the discretion simply not to issue the complaint if he or she chose, but the practice is that the input of the complainant or the police officer is solicited and agreed upon. The court's observation that this acts much like an informal mediation dispute, as it's observed in each of its decisions, is an accurate depiction of what takes place with respect to the conduct of these hearings.
Does the clerk magistrate also have the discretion not to find probable cause, even if there is evidence of probable cause?
I understood that suggestion being made in the Globe's reply brief. To the court's point, I don't think that that would be very intellectually honest. I do think that there's probably a mass data coding issue here. If in the supplemental record appendix in the last page, SRA 15, one of the codes is sufficient facts found to constitute probable cause.
What is that?
It seems as if what that gets interpreted in, because there's not a separate section in the data as reflected in the record appendix that was delivered to the Globe, that seems to get interpreted in as probable cause has been found. But I think to the court's point, and hopefully to the outcome of the working group, it may be that some supplemental coding actually will probably address this. The association would argue that it wouldn't be appropriate for the court to suggest, look, if you find probable cause, just say you didn't. That's not something that anybody wants to endorse. However, a finding of sufficient facts to constitute probable cause is something that's familiar to all of us, and it probably is an appropriate outcome without the probable cause finding itself.
Are you basically equating that to a finding of sufficient facts and a continuance without a finding?
I do believe that they're analogous, Your Honor. And I think some better and more acute clarification of the results of these hearings would probably be instructive. I do think that one of the points that's powerfully been made by the amicus parties is that the parties who are most affected by the request that the Globe has made are the accused. And the standards speak to this rather eloquently in terms of saying this is a hearing in which we need to protect the rights of the accused. Because if these 18,000 people suddenly have their names published, and although Mr. Albano says, well, the Globe's not going to have the stamina or cost or expense to review every single one, it doesn't take much, especially as our means and manner of record keeping becomes more and more sophisticated and available, to know that TransUnion or whoever is going to have every single piece of that information. Then I've been found of having done something to constitute probable cause. My employer, my landlord, my educational institutions all have that information. And where is my recourse? There's no criminal process that exists, and there is nothing for me to say or do, nor any way for me to address it in that instance. Mr. Albano argues that it's different when the district attorney makes the decision not to charge, even though he or she finds that the facts exist, because there's electoral accountability. But there really isn't, because we do not know, nor do we have any access to all the decisions that the district attorney makes to charge or not somebody. Those are not public appropriately. Similarly, when the police officer at the hockey game observes that altercation and he or she decides it's not something where I feel an arrest is warranted, there's no further disturbance, nobody's at risk, I'm not going to make an arrest. That police officer is not charged with making a public report with respect to that. He or she exercises their discretion and their judgment. And that's in essence the bottom line here with respect to with respect to what's going on, with respect to the conduct of these hearings and the issues that have been importantly raised by the petitioner. But there needs to be some trust in the system.
Well, along those lines, and I think the point you're making is important, it might well be that Court X and Court Y have different statistics because the assistant clerk magistrates who do the hearings might have more agility and are able to bring people to a satisfactory compromise better. It may be that in a particular court that an attorney's doing well, he's more Clarence Darrow than Hamilton Berger. There's all sorts of reasons that are not untoward. But having said that, does your client support the proposals by the ACLU as far as producing that type of information?
Certainly, the association supports the accumulation of data. I don't know that the association would endorse all of the 11 to 12 categories that the ACLU has delineated, and the association, as it's argued in its brief, believes that though the particulars of those decisions are best worked out in the context of the working group that's working at this time on those issues. A lot of these things, as the court is aware, also involve day-to-day the practicalities of how these things are going to take place in terms of making these rulings and effectiveness. We look at, over a 2-year period, some 64,000 hearings that have taken place here, and the suggestion that that we consider on a case-by-case basis the issue of impoundment both affects an unfair burden on those who are unrepresented and unsophisticated, and also raises a more important question. What party charged with probable cause, and which the clerk magistrate has found or found sufficient facts, and no complaint issues, who shouldn't seek impoundment? Of course everybody should seek impoundment. Why would you not seek impoundment? So the presumption that we'll just make everything public and then flip the burden on its head to have everybody seek impoundment, we know as a practical matter from being in the court system that that's not going to be effective. And we know the people who are going to lose out. They're not the well-represented, they're not the well-lawyered, they're the people who are unsophisticated, who do not have counsel, who are going to be at risk. Those are the people we're putting at risk by saying, oh, make reference to the uniform rules of impoundment, or we're also imposing on the system, another 64,000 hearings to make the impoundment decision. And we're conflating two areas of the law. The court's rulings with respect to impoundment are difficult to meet to establish impoundment. And so what's really being suggested here is a different standard. There is no need for a different standard. There's a need for the maintenance of the current standard, which is that these should be non-public records, and that impoundment is not a remedy that would be effective to address the outcome that the petitioner seeks in this case.
Now, you said that there's a need for a certain degree of trust, which leads me to remember President Reagan saying, trust but verify, with regard to the negotiations in Reykjavik. What degree of verification do you think is appropriate to mirror the reliance on trust?
With respect to the court system's ability to police itself and the rights of those who are involved, one, as the courts made clear, there's an absolute right to go to the district court judge. That hearing is not an appeal. It's a de novo consideration of the issue, and every complainant who is dissatisfied has that right. If the complainant, which is in the vast majority of these cases, is a police officer, the police officer certainly has the ability to proceed. The district attorney certainly has the ability to proceed independently and unilaterally. So we have a system where there's an immediate access to the district court judge. With respect to the larger concerns, maybe we're not getting everything. Maybe the complainants are not seeking a de novo review when they should, or not understanding that as well as they should. Yes, the accumulation of aggregate data is important to that. But also, we should be mindful that these are not systems where there's just a clerk magistrate. There's a clerk magistrate. They're part of the district court department. Chief Justice Dawley certainly has no interest in allowing matters to be adjudicated on the basis of favoritism or in a way that's inimical to the interests that this court has articulated that should guide us in carrying out these judicial functions. So we have an oversight which is comprised of other human beings, other courts, this court's general superintendent's power, and we have the ability to aggregate data and use those tools and effectively to observe and supervise. But the cost of oversight being impugning the ability of these accused is a cost that's too high in this instance.
If we require grand jury proceedings to be recorded, why should we not also require these to be recorded?
Thank you, Chief Justice Gantz. So the rule for recording right now is that matters are recorded in two instances. One, the clerk magistrate decides that they're going to record. And as the court has observed, about a third of the clerk magistrates have made that decision uniformly. Other times they do it on a case-by-case basis. Two, either party requests that the matter be recorded. In those instances, the clerk magistrate makes a decision, or either party requests the matter should be recorded. Why? To answer Justice Gaziano's question, what's the downside of recording? The downside of recording is this. When we have mediation, which this is a mediation proceeding, we have mediation in a civil case, we're not recording the mediation. And why not? Because if I'm representing a party and the clerk magistrate says, hey, did you hit him? If this is an informal mediation and there's no recording, then I'm going to let my client respond appropriately.
Do you remember the days of the lobby conference?
Certainly, Your Honor.
All right, when they used to be held in lobbies?
Certainly, Your Honor.
All right, I remember those two being dragged into many lobbies. And at one point, this court said, stop doing that, do it on the record, because we don't want these unrecorded comments, and it doesn't serve the public well. And everybody said, well, if we do these at sidebar and they're recorded, nobody's ever going to plead guilty. We'll never be able to negotiate a case. And that fear was unfounded. And the lobby conferences that used to happen in the lobby now happen at sidebar and are done just as effectively. So there's a scare tactic to say, there'll be no candor, we won't have a case be settled if we record it, versus we can do this out in the open and have a recording of it in case we need one later on. Because once you haven't recorded, you haven't recorded, and there's absolutely no record of what went on. So tell me about that lobby conference analogy and why I'm wrong.
And not wrong, Your Honor, but I believe
Sometimes I'm wrong, so please
I believe
tell
there
me.
are arguments that address the issue. There are two distinctions here. One, in those lobby conferences, everybody's got a lawyer. There's a guy with a suit and a tie standing next to you, and the parties are much more sophisticated.
For the record, sometimes a woman.
I apologize to the court and the parties. So everybody is represented by counsel with respect to that matter. And also, one of the things that happens is the court says, what happened when you lost those lobby conferences, when Judge Zobel stopped making you stay in his courtroom for 3 weeks until your case settled, was that now what they say to you is, look, if the parties want to mediate, here's a list of 15 mediators. We have a mediation program. You can go to those mediators. And that's how most of those matters, especially on the civil side, get resolved. The parties say, fine, we'll go to the mediator. And when you go to the mediator, the first thing that happens is they pass a piece of paper around and everybody agrees to treat what happens in the mediation confidential.
No, I'm talking about the criminal context, where now people being dragged up to sidebar. And people are out, the DA says what the DA wants, the defense attorney says what the defense attorney wants, the judge speaks candidly, and the case is settled or not settled.
The sophistication of the parties involved and the parties through who they speak are much different than a case where two mothers have had a fight at a hockey game and they both come in unrepresented in that instance.
But what difference does that make, really? I mean, whether they're represented or they're not represented, it's still the function of recording the negotiation and making a record.
Because one, the sidebar conferences do not take an hour or so. There's not a large emotional outpouring. When parties are represented, it's not, and she never respected me. And I mean, these are very emotional places for people to put everything out. And a lot of what happens, as I know the court is aware, is that what many people want so much is not an outcome, but an opportunity to speak to what aggrieves them.
So,
But don't we want to record the village elder coming to a resolution, as opposed to what has been reported in the Globe, someone saying something like, I'm going to give you a break because I like your lawyer?
When you put the tape recorder in the middle of the table, I think it's hard to argue that everything doesn't change. One, you're probably better off having a counsel there. Two, you ought to be a lot more mindful about what you're saying with respect to that. So I think it is...
Don't we want that?
What?
Don't we want people to be mindful of what they're saying?
I mean mindful not in the sense of intentional and honest, but mindful in terms of not being willing to discuss things with the type of detail and personal accountability that can sometimes lead to a resolution. So I think that when you put the tape recorder on the table, that it changes everything that happens. And with respect to the issue, one, the clerk magistrate can make the decision, and two, either party who wants it recorded should have the right to have it recorded. So if the parties are advised of that, and here's a form, if you would like this recorded, you may have it recorded.
Mr. Haley, isn't the concern, and that might be able to be addressed, is that anything that the parties say, if there's a criminal complaint, could end up being a statement of a party opponent that would be admissible at the trial. And maybe the solution is to address so that doesn't happen. I don't know, but the recording seems to be pretty important. I understand what you're saying. I completely understand what you're saying, but I'm not sure that everyone said, you put that recording on when the defendant's making a custodial statement after Miranda, Giambattista, everything's going to change. And it's actually worked out quite well. It seems that having a record is really important. And maybe the problem is to come up with the concern that you legitimately raise about the implications of what's said.
I believe that in cases where neither party has requested a recording, that the absence of a recording would continue to facilitate resolution of these matters.
But as Justice Gaziano said, I mean, that's what everyone says, but it doesn't, that's what everybody said with lobby conferences, that's what everybody said with Giambattista, and it just doesn't seem to happen that way.
Respectfully, Your Honor, we have 75 years of experience with respect to Chapter 35A hearings in which the issue of recording has remained discretionary, and those hearings have worked tremendously well, as attested to by the amici who have filed briefs in this case. They are powerful and effective tools through which the clerk magistrates have been able to resolve these disputes. The concern that's articulated by the Globe and reflected by the court's concerns and questions as well is that we're afraid that some undue and malign element of humanity is creeping in here, that there's favoritism expressed, that it's hard not to understand your implicit bias when you're working with people you know every day. But the reality is that there's another form of empathy and humanity that comes in here and is more at play. And that is the empathy and the humanity that's reflected in the situations which have been articulated by the amici, which is, the mother who maybe not forgot to insure her motor vehicle, the partner who's being charged with assault, but it's clear from the fear in her eyes that the clerk magistrate can observe that what went on here wasn't something where she was the aggressor and not something where, yes, she committed an assault and she struck the other party, but there shouldn't be some record that says, oh, probable cause existed to find her guilty of assault. And there should be an ability to exchange that information in a confidential manner if that's what the parties desire. There is humanity that creeps in here, but the humanity that creeps in and the judgment that is made is the judgment and humanity that's reflected in the briefs that the amici have submitted. And that is that clerk magistrates, men and women every day, express their humanity, convey their empathy, and make human decisions about what's right for the communities that they work in which they oversee the courts. It's a system that's worked very well. Does it need continued oversight and refinement? Undoubtedly. Is the trial court in the midst of doing that? It certainly is. Does the working group say, we want to see what the outcome of this case is? Yes, it says that, but obviously it needs to know what the outcome of this case is. If the court decides that everything should just be public, then the issue of recording really doesn't make much difference, and it's obviously changed. But this is a system that is an effective and powerful tool. Whether or not it is public or non-public, the court has already decided in Eagle Tribune in 2007, coming back and saying, you said all of it was non-public, what about if I just have part of it? Doesn't change the analysis here. And for that reason, the association, together with the other amici, would ask that the court answer the question in the negative and not change something that's an effective, powerful tool that's working for the people in the Commonwealth, and change it in a manner that's going to inflict permanent and irreparable harm on the people who stand accused of small matters for which sufficient facts might exist, but for which any party in their own human judgment have determined that no complaint should issue.
I have one final question for myself, and that is, considering the interest that the Boston Globe was bringing and the concern about lawyers advertising that they have a specific success rate in clerk magistrate's hearing, would some of this be alleviated by amending the rules regarding lawyer conduct and advertising?
No lawyer should be advertising that they have success with respect to clerk magistrates' hearings. It's not something that's appropriate for a lawyer to do, because the implicit suggestion there is that somehow they have an in. It's the same way in which we do not refer to the court or justices in an overly familiar manner. We conduct ourselves impartial, and we don't attribute any connection to a particular judge if we encounter them in a professional or social setting. That's entirely inappropriate, and the court's suggestion is one that the association would endorse.
All right, thank you all. Case was well briefed, well argued. We appreciate all of it. Thank you. And if I can confer with the attorneys with regard to Commonwealth versus Watt very briefly before we